So I just want to make it clear that it applies only to students and only in colleges where the CDC is there and has prescribed a uniform, and it does not apply to teachers or staff or any of the sort.
One right has been even given more prominence than the other. It's the right to education versus the right of religion.
Nowhere in the judgment have they made it clear as to what comes as a reasonable restriction.
Those Muslim students who want to wear the hijab now will be forced to choose between the right to religion and the right to education.
There is no logical or legal or any scholarly rationale as to how they are qualifying, what they are qualifying as qualified public places.
On February 15, the Karnataka High Court dismissed all petitions that were filed by student petitioners from Udupi, and while doing so, the Karnataka High Court also said that hijab is not an essential part of Islam and thus could not be protected under the fundamental right to religion. Now, within the last 24 hours, several people across the country have expressed their intention to appeal against the Karnataka High Court verdict, and some of them have already approached the Supreme Court too. The Supreme Court just a few hours ago said that it will consider taking up the matter, the appeal, after the holy recess. But in the meantime, there have been several questions raised about the 129-page order copy of the Karnataka High Court as far as the hijab case is concerned. To take a closer look at this order copy, I have two panelists with me. First is Syeda Saba, who is a practicing lawyer from Bengaluru, who has been going through the order copy and will talk about the finer points. And the second panelist today is my colleague Sanyukta Dharmadhikari, who also has written extensively about the order copy and also has been closely monitoring the hearings and has written for us comprehensively at the News Minute. Thank you, both of you, for joining us. Saba, I want to come to you first. What are your first thoughts on the order?
Hi. So the first thoughts are disappointment, because even if you look at how the petitioners are feeling right now in a few press statements or say their statements, they are disappointed because they approach the High Court with a hope that their rights will be upholded, and their constitution in general will be upholded, which didn't happen. But this is not the end of it. And like you said, there are talks about it being appealed in the Supreme Court. I think the initial giveaway from the entire judgment um, is, without looking into the details or say the nitty gritties of it, what has come out and what has to be made really clear is that it's not a ban. I have seen, all these news channels and other reporters calling it a ban, WhatsApp messages or whatever be it. They've been calling it a ban. A ban would be complete stoppage of something, which is not what the order is saying. The order says, in the end, it just says that if a college has a CDC which has prescribed a specific uniform which disallows the hijab, then the hijab cannot be worn. Which means that if a CDC has no specific rule as to wearing the hijab or not wearing the hijab, it's not applicable to them, and students can still go and wear the hijab, go to their respective educational institutes wearing the hijab. And this is applicable only to government colleges and not private colleges, because the CDC is existing only in government spaces. Because the private institutions have their own management and how they deal with their day-to-day functioning. So I just wanted to point this out, that it applies only to students, especially because we'd seen in the interim order when it had come out, some sort of vigilantism had started, where they started applying this to teachers, where they started applying it in private colleges, and in places where the CDC had not even prescribed the uniform, right? So it sort of completely turned over, and there was riots because of this. So I just want to make it clear that it applies only to students and only in colleges where the CDC is there and has prescribed a uniform, and it does not apply to teachers or staff or any of the sorts. So that's like the only giveaway from the, like, if you have to summarize it as to what in the end did it hold, and this is not a ban.
Sayukta, your key takeaways from the order copy?
Basically, the Karnataka High Court said three main things: that hijab is not an essential religious practice under for Muslim women under Islamic faith. Secondly, the order of the school imposing a dress code or a uniform is fine, it is valid, and it is a reasonable restriction under fundamental rights, as there are reasonable restrictions given in the constitution as well. And the government also, the High Court also said that the February 5 order of the Karnataka government that said that there should be a dress code in place and the dress code should be followed in whatever institute if there is a dress code, that order is valid. It was one of the things challenged by the petitioners. So the High Court has said that this is a valid order. So which means, like Sabha said, that in places where there is a in government institutions in Karnataka where there is a mandated dress code that disallows the hijab, students will not be allowed to enter classrooms without it if the college so decides.
Right. Sapa, I want to ask you why one of the petitioners did speak about the hijab being an essential religious practice in Islam. Do you feel that there was perhaps disproportionate focus in the order copy on just this one aspect?
Okay, see, I it was one of the contentions that the petitioners had made. There were so many other petitioners who had made contentions in respect of freedom of speech and expression, freedom of conscience. Like there were many arguments or many points that were placed, and from like the reading of the judgment, most of it was spent on whether it's an ERP, which is essential religious practice, or not. I don't know if I can call it disproportionate, like on the face of it, because I feel like if they could have also shed some light on how this is a violation or not a violation of the other rights like speech and expression or conscience or equality or non-discrimination, it would have made more sense as to why that reasonable restriction, as Sanyukta was saying, can be applied, because nowhere in the judgment have they made it clear as to what comes as a reasonable restriction. Now, even if you do reading of all these other articles in the constitution on equality or speech and expression, the reasonable restriction can be applied only in certain scenarios. It's not a very vast thing, it's a very limited space. Say in cases of public order, in cases of protection of the sovereignty of the state, in cases of maintaining peace and things like that. But in nowhere in the judgment has it said once as to why this restriction is applicable. They just say that because there is a reasonable restriction and we are restricting it, but there's no reasoning as to why this reasonable restriction has to be applied. So, I mean, ERP is also important, but yeah, you can say that they could have concentrated more on the other rights also, which were contended in the petitions.
You were speaking about reasonable restrictions. In fact, the High Court has said that in public places, in qualified public places, and uh, in a for certain category of people, there are reasonable restrictions. They have said about they have spoken about qualified public places, and they have said that like an under trial detainee does not have absolute freedom of fundamental rights like that. Do you think there is I just wanted your comment about this similarity that the uh, High Court has pointed out.
Okay, see, I also found that it was very unreasonable to compare, to bring any kind of comparison, right? The reason why, in their own words, the detainees or the prisoners also have rights is because they are humans, correct? And nobody is, and like, see, even when you talk about restriction on these people's rights, we are not saying that they don't have these rights, and their restrictions will are not in respect of reasonable restriction. You cannot say a prisoner does not have the right of equality because he's a prisoner, and that's a reasonable restriction, right? The prisoner will also have right of equality. And so that was one thing, that the comparison was completely, I mean, if I can say, unnecessary, respectfully unnecessary. But in the aspect of qualified public places, What we need to see is that they don't define what this qualified public place is. There is no logical or legal or any scholarly rationale as to how they are qualifying, what they are qualifying as qualified public places. Nowhere in the judgment do they mention from where they're deriving this concept altogether. Because, see, we've never heard of what a qualified public place is, and for them to then go on and say, okay, courtrooms, okay, this, all these schools, all these come under qualified public places, it's a little
Different
vague.
camps have been called qualified public spaces too. So
Yeah.
yeah.
So how are you comparing all these things? I mean, so I don't know why, if they use that term, it would have been so much more easier to understand from where their understanding of a qualified public place is coming from, and how even in that qualified public place your right can be restricted, because that's the whole,
Logic,
like
reasoning
the
they have given.
flow of it, the flow of it. So even if it is qualified public place, how can you restrict my right, and why will you restrict my right? Take an example of, a war room or a courtroom being a qualified public place. Are you going to say that in a war room, my right to equality, my right to speech and expression will be restricted because it's a qualified public place? Like, where do you draw a line as to how much and what you will restrict? So that's really vague, according to me. And
And you
yeah.
worry, Sabha, but that by extension, now, I mean, since there's no definition of what is a qualified public space, now this argument can be used anywhere. The restriction of wearing hijab now can be extended to other places by saying this also is a qualified public space. Is that a worry too for you?
It slightly is a worry, because leaving something so broad always causes problems. But like I said, this particular judgment will not be applicable to all these places, because they are saying our order is only respect of these colleges and CBC and what their powers are and the government order and so on and so forth. But there is a possibility of it being quoted, because that's what happened with our interim order, right? They said that high court order is there and that's why you can't wear it, even though you're a teacher, even though you're a private college, there is a high court order, so you can't wear it. There's a possibility for that to happen, where the public takes a certain understanding of this certain term or aspect of it and probably misuse it. It is quite worrisome.
Right. Sayukta, you have been tracking the hearings closely, like I mentioned. There was also, a point raised by the petitioners that, Muslim women, Muslim young women in colleges are being discriminated against, and they're being singled out as well. Whereas, there is no talk about wearing of, say, a Mangal Sutra, or in this case, they said bangles and dupattas, right? So that is not at all mentioned, forget addressed in the order copy. What do you have to say about that?
Yeah, very interestingly, this is what I found out as well. This struck me as well, that senior advocate Ravi Verma Kumar, who was representing one of the petitioners, uh, he said that Muslim girls are clearly being singled out. Only this February 5th government order is to single out these Muslim students. If dupatta and bangles are not banned, why are only these students being asked to come to classrooms without a uh, why are these people being made to remove their hijab? So yes, that part has not been addressed at all. Even in the whatever interlocutory applications that were written given to the court in form of written submissions, even those I believe had some mention about this kind of segregation of some Muslim students being who decided to wear a hijab, then being sent to another classroom, and all of that. We saw all of that. We had visuals of all of that. None of it was mentioned by the High Court. So it has, like I like respectfully, I would like to say that it has not mentioned this part as well, and it has glossed over. It has only focused on what the Quran says and whether the college is allowed to make such decisions. But this aspect of discrimination, which is also a breach of fundamental right, of the right to equality, this right has also been somehow not considered in that high court order as well, if I may say
So, in
so.
extension, would it be fair to say that some fundamental rights have been chosen over a few others? Would that be a fair assessment?
I would say that it's in a way. I'm sure the High Court did not mean to, but somehow it has pitted one right against the other. I don't know if I can say again. One right has been even given more prominence than the other. It's the right to education versus the right of religion. Those students who want to wear the hijab, those Muslim students who want to wear the hijab now will be forced to choose between the right to religion and the right to education. And this was a point that the petitioners also raised, and they had also said that this interim order not allowing the hijab is a suspension of their fundamental rights. And all of these aspects, I think, have not been addressed, and unwittingly I feel the high court order has pitted, while concentrating more on the on how you express your right to religion. It has sort of not spoken about the other aspects that the petitioners also had raised, that their freedom of expression is involved, the right to privacy is involved. So all of that the high court does not speak about.
Right. Sabha, another statement in the order copy caught my attention, where the High Court has said that clothing items such as the hijab and headgear may hinder the process of emancipation of women in general and Muslim women in particular. Now, as a Muslim woman yourself, and of course a legal expert, how do you view this?
Okay, I think I find that very problematic because emancipation, as they've said it, a simpler term would be liberation. Like if you tone it down a little in not courts language, liberation. So they're saying that it's hindering, allowing students to wear the scarf is hindering their progress. Now, I don't understand where this idea even came from, because the students who went there said, "Hello, we want to wear this. Please allow us to." Nobody spoke about they feeling enslaved by this practice. Nobody talked about how it's they're aggrieved by this practice. So, in my sense, when you are liberating somebody, there should be a need for being liberated, which I don't see anywhere. And to somehow justify this whole concept of emancipation, of hindering of emancipation of these women, they've quoted Ambedkar from one of his books, wherein he says, the whole parda system is like, it's quite bad. It does not allow women to go out. Um, it's good that they've quoted Ambedkar, but they also had to see in what context Ambedkar said that, right? Because in that that whole quote that is being referred to in the judgment, Ambedkar is talking about the parda system which existed, which restricted women from getting out of their houses, not going without a companion, which sort of secluded them inside houses. So that's the what do you say, view that Ambedkar was taking. And we also need to acknowledge the fact that Ambedkar has always been a critique of any kind of religious practice, right? Like there are a lot of things he's spoken about, which he thought was against this whole against a lot of religious practices. He's spoken a lot about it. Now to apply that in our current scenario in this case is not right, according to me, because over here these are women or girls who are voluntarily wearing the hijab, who are going to schools voluntarily. They fail to see this as a voluntarily expression of their faith or their choice or autonomy. Now for me, the problem lies with they assuming that these women have no autonomy, right? And all the activism that has been happening for the women's movement has always been about how you need to stop looking at us as ablanaris, because we are not. In a lot of scenarios there is some kind of autonomy that comes within, there is some kind of decision making that we are abled women who can make our choices. Now you are assuming that these women are being forced into it. Okay, for you to assume that the entire community is being forced into this is really wrong. For some reason, we didn't ask for a savior to come and liberate us, which is
Yes,
what
this
we
was
were
in
done.
fact reflected in our reportage as well, Sabha. In fact, many of us spoke to scores of students in districts across Karnataka, and many young women did tell us that nobody, including my parents, have enforced, and I have taken up hijab on my own accord. And yesterday as well, when I spoke to several parents, when we were trying to understand from them, will you now allow your daughters to go? Several of them said, we did not ask them to wear hijab. Now we will not force them to remove the hijab either. That's a choice they will make. And basis the choice they make, we will figure out how to continue with their education. So somehow maybe the High Court has failed to factor in the woman's choice and agency at all. And
Exactly.
that could, of course, be a larger debate that we need to see how we are looking at women. Because, interestingly, there was an opinion piece that I read a few days ago about how everybody wants to kind of monitor women's clothes. In colleges, we have dress codes where you're not allowed to wear what they call skimpy clothes, and here if somebody wants to wear a headgear, that also is too much. So how much should really women wear
It's
is a
really
question.
frustrating because the question is always about, oh, what is she wearing? Or what is she not wearing? Like, in the end, it's just that, right? And even more alarming, no, I won't say alarming, even more, I don't know, interesting thing is that the preface to saying how emancipation should be, like somehow make way for the emancipation of women was that they have quoted that India is signatory to all these conventions and protocols. So, like, you're so confused with it. You're saying that these protocols say that there should be no discrimination, that, women should be given all these rights and all these autonomy and the choice and whatnot, and their progress has to be looked into. By quoting the same conventions which are applicable to us, you are now saying that, okay, we are not going to allow you the freedom of choice, we are going to
Mm.
discriminate you because you are wearing the hijab. So, like, wearing, not wearing, like, and by asking somebody to not wear something, aren't you inter alia saying you have to wear something? So where do you make your stand? So I really don't understand why the court felt the need for it to come in and swoop in like knights in shining armors and rescue these apparently oppressed women. There was a running joke in the office when the judgment came out that, hey Sabah, looks like you have been liberated from 10,000 years of patriarchy. Like, congratulations, man. Now you're a free woman. So, like, I don't understand where this is coming from. Nobody asked to be emancipated, and not in this manner where you are dictating us as to what we can do or what we cannot do. That would not be emancipation technically.
Absolutely. The irony is not lost on too many people. Sayukta, in the run up to the judgment, you have been closely monitoring what the AG has been saying. And there was also this equivalence that was created, saying that on one side, one set of students want to wear the hijab, the other set of students want to wear saffron shawls. So if we allow both, it will lead to a law and order problem. One of the things that AG presented. Uh, so, do you worry that somewhere a false equivalence was created, although this judgment only talks about the hijab? And I just also want to, ask what are your thoughts on the court saying that some unseen hands were at work to engineer social unrest and disharmony by blowing the hijab debate out of proportion? How do you view this?
Well, both of these aspects were a part of what the AG submitted to the High Court. They said that actually the petitioners had also mentioned that there are counter protests happening because these six women, girl students, want to wear the hijab to school. They are saying that now students are wearing saffron shawls and coming. I think there is a false equivalence because these these girl students do wear the hijab outside the school, but these other saffron shawl students did not normally wear these saffron shawls. It's not their everyday practice. I can't say in religious practice because now the High Court has said the hijab is not a essential practice, but that is not what they usually wear. So yes, there was some sort of, I think the High Court did uh, feel that in it's passed a order that no religious clothing should be allowed. But I feel Sabha will also be able to explain better that how it's bhagwa shawls and hijabs are different. So, and I don't know if the court was informed, but the AG very specifically spoke about. Actually, it was the college council, the council representing the college, who said that the CFI instigated this. But some, I don't know if the petitioners also told in their written submissions that counter protests were started because of after the discrimination, everything, counter protest started. I don't know whether the role of right wing organizations like we at the News Minute have found that these Bhagwa protests were also planned. That aspect I
Absolutely,
don't know.
because
The
we
High
have
Court.
reported from the ground that Bajrang Dal, Vishwa Hindu Parishad, and of course ABVP have all been actively involved in organizing these protests. So
Yeah.
yes,
So the High Court did speak about the CFI. They didn't mention it, but they wanted to know who started this whole row and why it started. But it has not said anything about, I, maybe it was not informed. I will give the benefit of the doubt. But this part of the role of the other side has not been brought out eh, inside court, I feel.
Uh, you know, I just want to know both of your thoughts. Please feel free to jump in. On what grounds can an appeal be filed now in front of the Supreme Court? We've heard from Asaduddin OAC to several people saying that this impacts Muslims across the country. So we will, of course, appeal against this in the Supreme Court. So I just want to know what are the grounds on which an appeal can be filed today? And either of you can jump in, Sabah and Sanyukta.
I feel the point of putting, like, one fundamental right versus the other can be brought out by the petitioners. If, like, I don't want to speak for them, but there could be one angle where this case could go, where they can talk about selective fundamental rights having selective kind of reasonable restrictions on it, is what I feel. What do you feel, Sabha? Do you feel
Okay, before we get into this, I had just one point to add to what Sayukta was talking about, like religious markers and how they have dealt with it. If I can.
yeah, yeah.
Okay, so you're right. What you said was they somehow created an unequal comparison between the two. That's true, and they said why allow any religious marker whatsoever in any educational institute. So their whole argument in the judgment is has kind of strayed away from what was the issue at hand, and they've started looking at whether uniform is unconstitutional or constitutional. If you do reading into it, that's what it looks like. And they're saying why are we allowing religious markers in any for anybody in a place like school. um so I was reading into this, and the reason why they say is because we have to uphold secularism, and that it's against secular values to have allowed all these things. So I want to just point out this extra information I came across when I was reading into this whole point of religious markers. So when constitutional debates were happening over amendments, there was a petition. We don't call it a petition. They tried to move an amendment to the draft Article 19, and say that disallow any religious markers, freedom of religion, but it should be in private spaces, but it should not come out as publicly, and there has to be no religious markers. So he it was by Tajmul Hussain, and he said, we all see that in India, we being a secular state, we should not have any kind of attire that shows to the public that we are belonging to a certain religion, say be it dhoti. By the names, by the way they dress. If it's wearing a dhoti, we know it's a Hindu. If the person is wearing a kurta pajama, they're Muslims. So you need to get rid of all these things, and that there should not be any religious marker attributed to any person because we're a secular country. Now, and then the counter to it was really funny, because another legislator said, if that's the case, then you will have to change your name, because Tajmul Hussain, I know that you're a Muslim. So the idea of secularism enshrined in our constitution is not that we will dismiss all the religious beliefs and religious markers or anything. It's not about okay, let's tone down this, let's make the plane straight. It's about acknowledging and respecting each other's religion and co-living. It's about
I think it's
saying
called
that
positive secularism or something.
yes, that's what
It's
they
not.
call it as, but they
Yeah,
really don't go into the actualness of what positive
basically.
secularism means, because right now what they're doing is like, let's not have any religious representation in schools at all. But
It's
that's
more of.
not what.
But Sabha, I want to know: does this, will this extend to other religious markers and symbols? For example, many government schools I know in Karnataka allow, for example, a bindi or perhaps a sacred thread around someone's wrist or sacred threads around there. So, will all of that be banned too? How will this be interpreted now?
The thing is, when this was brought up, the court in an oral opinion said, those things are not challenged before us, so we can't read into these, is a
Yeah.
statement they made. But yes, as per the judgment, they have just disallowed hijab, and only on if the CDC disallows it. That's
Uh,
the only thing.
Before we wrap up, I just want to understand from you, Sabha, how, and Sayukta, of course, feel free to jump in. How will this judgment now have far reaching repercussions in other parts of the country, in other aspects of our society? How will this have impact?
For one, uh, Muslim students cannot enter the institute wearing a hijab. So their demands are still continue will still continue to remain unfulfilled. They will still face the risk of not being allowed to wear their give their exams wearing the hijab. And this may somehow prompt even other colleges that don't have a CDC, that don't have a dress code, to just be safe and avoid any kind of to avoid kind of conflict. They might also introduce such a rule mandating a dress code, just to avoid a law and order situation, because we saw hijab wearing students being heckled and being run behind and everything. So just to avoid that kind of situation, private colleges may, like we saw happening after the interim order also, it may still increase now that that interim order has been, you know made final, and that kind of has not been addressed in the final order. So that is also, that is also a risk that this kind of law and order situation may arise at more, even more places, because of this decision.
Adding to what Sayukta just said, she's right. They have not really addressed the right to education aspect at all in like the entire judgment. They just say that it's not violative of our right to education, but nothing more. But the implications of it on the ground would be either the girls will quit, they will stop going to schools, because if like we were talking about how it's pitching one right against the other, they will quit, or they will have the option of say going to other minority institutions which allow the wearing of hijab, which as a principle in their schools and colleges itself they allow. Now what happens with that is they will have less exposure to the outside world. I'll give my example. The reason why I have certain opinions or certain ways of life is because I was exposed to a greater or a larger picture and a larger crowd, and that like helps in growth of thought processes. So that will be stopped. And the fact that they will stop going to school, we are back to square one. All the efforts we've made to make sure girls end up in schools is just going to fall apart. And like the such a report which talks about how there is so much disparity in the ratio of how many students are in schools, how many Muslim students are in schools, and then again how many Muslim women students are in schools. It's going to create a very large impact if that's to happen. And also it's like a trend in our country where the Muslim community has been constantly being disappointed by the whole system, and like criminalized or patronized, or all that has been leading, it's building up. Now one more step, now they are feeling criminalized for wearing a hijab, and like this is happening in an area of education which it shouldn't have gone to. Like you monitor everything, but education is something that we all feel the same way about, and so like stopping that and causing hindrance to this, will have a huge impact. And the fact that now it's a three judge bench judgment, it will be quoted in
Yeah.
multiple other places. It's not just Karnataka now. We saw incidents where things like this happened in, say, Bihar or say other parts of the country. Now this will
It's it
become a
sets a
trend.
precedent.
Yes, it sets a precedent, and the fact that it's a three judge bench
It's a
decision,
it's
it's
a
going to
heavy
have a
adjustment.
yes, it's going to have large implications, and
Yeah.
it might spread to the whole country where they will bring up rules if there aren't any.
Yeah.
So it,
And
it gives a huge scope. And like we were talking about, if the CDCs didn't have this rule then, like Sanyukta was pointing out, they will come up with it.
Yeah, absolutely.
so much
The irony,
so
yeah,
basically, to try and emancipate women, we are trying to, the high court ended up risking the
absolutely.
education of
The
Muslim
education
children.
Rest
of
of the women
Muslim
of the
girls has
country.
Mm,
become a
Yeah,
collateral
so
damage.
much
And of
so
course,
now.
we'll have to see the attrition rate if it does shoot up.
mm,
And even if it does by 1 or 2%, that's a huge loss.
that's a huge loss.
Of course, we will continue tracking how this case pans out. We'll of course also track what happens in the Supreme Court. But in the meanwhile, do visit our website where we have put out several stories for the last few months. My colleague Prajwal has been at ground zero in Udupi from day one, and Sayukta has been also tracking what's been happening in court. Do read our work, do watch our videos on the News Minute. And if you want us to continue doing independent and unbiased journalism, you will have to do your bit. Make sure that today you go and visit our website, click on support us, and do your bit to make sure that we continue being unbiased and be only your voice. Thank you for watching us. Thank you both Saba as well as Sayukta for joining us today.
Thank you.